Okay, Oak Sparrow Properties, and Sandy Property Management versus IMAX Web and Erica Web. 24-08588. Appearance for the record, please.
Attorney Your Honor, Jessica Larson, appearing on behalf of the plaintiff and the representative of the property, Sandy Bailey Bristol, with the name to my left.
Please state your name, please. Erica Web. And your name? Okay, today was the date that was scheduled for hearing for non-payment of rent. Did the parties resolve this matter?
We have not, Your Honor. We've been talking since we got here at courthouse today, and we're kind of at an impasse at this point. The defendants have moved out of the property, so we're really just down to what are the damages that were incurred in and rent, Your Honor, obviously unpaid rent, but also damages that were incurred to the property once my clients reached possession.
Well, we're not dealing with that today. That could be severed and dealt with at another time. This is for non-payment of rent, correct?
Yes, Your Honor.
Okay, so the possession is not an issue.
Correct.
Okay, and there's a past due rent?
There is, Your Honor.
You filed for money damage?
We did.
How was the past due amount?
And to be honest with you, I've got a typo on the ledger that I'm trying to understand. And we're reaching out to the person who does the bookkeeping for the property to understand. There may be an error on here, but I believe through December, it was $3,446.
You dispute that?
Yeah.
3,446.
446.
And what do you believe it should be? Or do you believe you owe any money at all?
Yeah, we have an email with the last statement reading $1,147. $1,147.
You believe you owe past due rent of $1,147. You don't have a valid or accurate, I should say, ledger at this time.
You know, as we got here today, there's a discrepancy on the ledger that my client is not able to explain. We're reaching out again to the bookkeeper to figure out this may just be a typo on the ledger. So I'm trying to figure out if maybe something didn't get deleted.
And they got a copy of that ledger.
I can
Correct.
I have that next one from right here.
We don't have a paper. It's just yeah, I looked it up in the email.
Okay, and you have, what is this email that you say you owed $1,147? When did you get that email?
It is from the lease statement. We received that email. It's the updated balance of October 1st, and then
October 1st of what?
Last year, 2024, and then October 7th, we got another email stating that they wish to not move forward with a lease resign.
Okay, so
That's the last thing that we heard.
would have, okay, what about the other months after October? Why don't you owe for those?
We never got any update for that. We was coming to the understanding that in that email that they told us we had to November 30th to move out.
Okay, so you got a notice that you had to move out by November 30th?
Yes.
When did you move out?
December 6th.
My client didn't get notification of the move out until December 23rd. Your Honor.
I have the email right here.
The email saying what?
That would be out by tomorrow, and it's dated for 12/5, and it's to their,
I feel it's suggestion.
to Jennifer Wilson.
Can you provide me proof of your notice that you advised them that you were moving out December 6th? And what date of the month is your rent due? The 1st? Okay. And you're saying that your client got notice the
Right here,
26th?
everything will
The
be
23rd.
out by Friday.
Provide me evidence
26th.
of that, please.
I do have the.
Can you get that to me? Please?
And then after that was the next, that's the email stating that we would be out by tomorrow. That was.
Who's Jennifer Wilcott?
She's the bookkeeper for Sandy Properties.
Okay, this saying that you'll have everything out by December sixth. When did you turn over the key?
So I left the keys because I had told them that they, I had left the keys on the ledge in the house because they were coming there to do a city inspection or something, so I left them there for them.
So you moved into your new home? Something ring? You moved into your new home when?
I moved with my mom
Okay.
and I just moved into my new home.
Do you have any record that would dispute that they didn't vacate on the sixth as they notified?
I'm fine searching through for records right now.
Okay, you all can have a seat back there. I'm gonna call the next case. On the record. In the matter of Jolly Road Investments versus Family Dollar Stores, 4-00812. Oh, it's a step in order to adjourn on that one over here. Sounds good. Okay, on the record in the matter of Hunter Town Properties versus Ronald Ballard, 25-01153. Appearance, please.
Good afternoon, Your Honor. Brian Tanger.
Plaintiff, P 80491.
Good afternoon, Your Honor. P 86222, Elijah Tyra on behalf of the defendant.
Ronald Ballard. Okay, today was the date scheduled for hearing for non-payment of rent. I have a notation here that there is going to be a conditional dismissal.
That's correct, Your Honor.
You can put the terms on the record.
Right now, the balance outstanding is $14,196.13. There is cost of $194.24 for a redemptive total of $14,390.37. Paragraph 3 states that defendant agrees to vacate the property and turn in his keys either on or before April 15th, 2025.
You have a copy of it, or was it filed?
I filed.
Yeah.
Filed very good.
Brother.
What's going on?
I don't know if it's a phone. It might be the child. That's fine. I think they're playing a game or something. I'll let the child slide. See, good signatures. There we go. Oh. Mr. Ballard, you understand that you have the right in this matter to proceed to a jury trial?
Yes,
Okay, you understand that at the time you have the right to present any evidence that you believe go to defense of why you should not pay this past due, right? You understand that? And so you would have to give up your right to have a jury trial if you wanted to move forward with this conditional dismissal. You understand that?
yes,
That's what you want to do?
yes.
Okay, so the past due amount plus court costs $14,390.37 for rent due through a period of March 31st, 2025. Defendant agrees to vacate the property and turn in his keys either on or before April 15th, 2025. What day does the rent accrue? What does it do?
I believe first judge.
So it's the second. We're not, are you waiving anything else? Is that what's going on?
Yeah, we were negotiating this over the course of several days, so. it's
Okay, sounds
not a
good.
big deal.
Okay, so you understand that partial performance will not satisfy this. You're agreeing that you're going to vacate the property and turn over the keys on or before the 15th, correct? It means you're also taking all of your items. You're not abandoning things for them to clean out. You understand that? Otherwise, if you don't vacate as you agreed, they have the right to have judgment enter against you without noticing of any future court date. Recognize that? Okay. Let's see. You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you've given up, you can return to the court and request to have this set aside, and we'll set this for hearing, okay? Do you have any questions for the court? Any additional matters for the record?
No, the plan's good.
Thank you, you all set?
Thank you. Thank you.
Good day.
Thank you. Is Lansing 74 LLC versus Gretchen Bogan ready? You all ready? Or no?
Not now. Should go talk to her.
Okay, sounds good.
Sounds great.
Which matter are you here on?
Thank you, Your Honor. On a man asset, I think it was initially inadvertently dismissed and put back on calendar. My client was noticed, but average party may not have.
But he was on two other cases and they were both set for a date this morning, so I'm not sure why. He was dismissed, and then you have a note, but case law on base, that's what the hearing is set for today. So,
These two cases were set for the same day, we scheduled for today. This was from a pre-trial, what was the pre-trial?
March.
Oh, great. And my note says that the hearing was set for today.
So just, I think it was inadvertently dismissed initially, and then it was corrected. My client did get the notice. But just based on changes, I don't know that the tenant did.
How was it inadvertently dismissed?
I was gonna say, I don't know if the dismissal was into an error, because the other ones weren't, but
There was other
it
matters
wasn't correct.
dismissed,
I did set it, no, the
Oh.
other two matters were not.
but they were all pre-trial on the same day?
Yeah,
My client received initially dismissal, and then shortly thereafter, he received a notice for today and this afternoon. So that's the reason, and me thinking it was a correction, given that the notice to appear came after the initial dismissal.
Okay, so civil would need something from me, I don't know what they need. You want me to set aside the dismissal? Maybe?
I imagine they would just reschedule it.
The other matter was scheduled for a hearing on the second. I mean, where were the other?
they were
matters at?
separate, they were this morning, pre-trial.
You have
Oh,
defaults on it this morning.
there was defaults on those other two. And then this one was supposed to have a hearing. Got it. And then the ones appeared today.
Yeah.
Well, if your client got a notice to appear today, then I would imagine that a notice would have went to the tenant. So
We
he
appreciate
can
it.
submit the phone.
Absolutely. We would be happy to do.
I'm sorry?
Yeah, we would be happy to submit. it.
Okay, sounds good.
All right, thank you.
Okay, have a good one. Same to you.
Thank you.
Just need to try it.
He probably doesn't want something. Okay, let's see, Dollar General, I think I took care of that one. That is Tammy Rogers and Alethea Moss Kelly here. No? Guess it's a little early. Are you all ready to go back on the record in your matter?
Yes, Your Honor.
Okay, back on the record in the matter of Oak Sparrow versus the Webbs. Council, did you get anything as it relates to an updated ledger yet?
I don't think Jennifer was talking, no, we haven't, she's been on the road, so sorry.
Okay, and then we were looking for where your client received notice that they had left and it was later than December 6th.
Yes, Your Honor. So I've got the email thread that I think that Ms. Webb had shown you part of. I've got the whole string. There was correspondence leading up that there was a walkthrough that was supposed to be scheduled in 12/5. I understand that there was some issues with getting that confirmed. The Webbs were having, I think it was having a baby or something in this
Our
email.
son had pneumonia and was in hospital.
So that got canceled and rescheduled on December 5th. And then Ms. Webb did say we'll be out by tomorrow. The bookkeeper again replied on the 7th, when do you want to do the walkthrough? On the 9th, are you ready for the walkthrough and to turn in keys? On the 11th, again, to Ms. Webb, we need to schedule the final walkthrough. What day this week will you be ready to hand in keys? And then it was on the 23rd, there's correspondence between Jennifer and Ms. Bailey Bristol, that the tenants are still responsible. The keys are turned in, aren't they? And I think that there was, I don't have the email, but I do. Later on in January, Jennifer confirms to Sandy that they told me on 12/23, excuse me, that they were out and where the key was. So I think that there was no indication that I see in any of these that they plan to leave the key in the property.
When was the walkthrough?
After they never did one. They moved out and,
So they moved out on the 6th. They never had a walkthrough. Guess it wasn't required.
well, it was required for the,
Why are you talking?
I'm sorry.
I don't even know where you're there, actually. She's not called a witness.
She's my client.
You're not called a witness. And when do witnesses just go blurting out on the record?
I understand, I apologize.
Thank you.
Your Honor, it was understood and it was in the lease that there was to be a final walkthrough, that was canceled due to accommodating the Webbs. And so when they chose to move out, they asked multiple times, can we do the walkthrough? And they never replied. So, and there was no indication before that the keys were in the property, that my clients had possession.
So, we didn't do the walkthrough. My son, I believe the email I showed you, he had pneumonia.
I only read the first page. You gave me your phone, so I don't scroll.
Right. But I did tell them that there was pneumonia and that's why we were needing to move out later. And they said there would be eviction and I didn't want to go through that process, so I let them know we'd be out by the 6th. And I was worried about my baby. I wasn't worried about doing a walkthrough. And then me and Jennifer did speak on the phone, and that's when I let her know what the keys were.
You spoke on the phone when? If she says that it was the 23rd of December, are you disputing that?
Yeah, I don't believe it was that late in the month.
Okay,
But I
And
did
so-
let her know that I did email.
so you're not disputing that you got an email that said that you owed about $1,147 in October, but you're also not disputing that you would still owe November and December rent?
So, we get section 8 and looking at this, like, they have that we owe 1,134 all the way to December 23rd, but we weren't out that late. But our section 8 also paid them in December. So
Section 8 pays your full amount of
like,
rent?
not the full amount.
What's your portion?
Our portion was $699.
$699 for December, or for each month, I should say?
Yeah.
Okay,
And I don't see any indication on the letter, Your Honor, that the section 8 payment was received for December.
That 801.
Yeah, I don't see that it was received. And if you moved out partway through the month, I don't know what section 8's policy would have been on that.
you say you see it on your ledger?
Yeah, we have the same one, but she's saying that that's not what
Let me
that's.
see.
That's the 801 charge, not the,
Can I see your ledger? And then I also want to see your email chain. Oh, they have the same ledger, I think.
yes.
Okay, so this says, oh, this is going back to November 2023. Let's see.
It's the last 2 pages. I was on.
Thank you. November or October, I should say. Is when they agreed that they obviously owed some money. I see a $1,147 balance, October 1st. I see that there. And then it looks like then on the 1st of the month, your rent of $801 was assessed, making your balance $1,948. It looks like they did receive section 8 for October 1st. That brought you back down to $1,147. They've attached a relatively small late fee. What is this, like a per day late fee or something? Is that what it's at?
$5 per day until you reach 50.
Got it. And then Okay. And then now October comes and looks like there's an assessment for $699 plus $801, the $699 being your portion, making your balance 18,900 and 1,800, I'm sorry, $96 once the $699 is assessed, and then the 801 making it $2,697. They did receive a payment from Section 8 for that month, but did not receive your payment. And so, November 5th, they start assessing late fees of $5. So you must get a 5-day grace period or something? Yes. Okay, and so you owe all the way through November.
And Your Honor, we reached out to them because we had gotten, there was a pipe that was leaking in the basement. And we had gotten a $600 Board of Water and Light bill. And Board of Water and Light told us to reach out to them to, so we could dispute it. And they said they couldn't do that. We explained to them that that would be why the rent would be late. I do have text messages. They said they couldn't because they couldn't speak on our account. I let them know they didn't need to speak on our account at all. The lady that disputes it, she just needed to know that we rented the property from them. That was pretty much all it was. And they wouldn't do that at all. So our Board of Water and Light was 600.
You,
600
It
and
was almost $900.
okay, what month was that?
you said what?
What month was that?
Was that October? It was October. And that was with Jennifer. That was.
You notified them in October?
I'm not sure if it was October or. Sandy was there when the pipe was found. She had it fixed immediately, but the water damage was already done.
I need to know when you notified them. of the
That's what I'm looking for right now.
It had to be that week on September 10th because the person that handled it was Paula Hatcher from the Board of Water and Light. And she was the one that was disputing the case. She was the one that asked to speak to that.
And my client is indicating that they did attempt to call and they weren't able to get anywhere.
It's on the phone.
What about on like? I don't know if maybe there's miscommunication somewhere
We
or
were
I
told
don't.
that they couldn't do it, and then no one ever.
They couldn't do what?
They couldn't reach out to Brenda, and then nothing, or Paula, and then nothing.
So
was happening.
my understanding, there was a pipe leaking in the basement. It caused your water bill to go up. And what was Board of Water and Light telling you you needed to do?
To dispute it, but they needed to speak to the landlord before they could dispute it.
Yes, because the young gentleman that I spoke to, he was able to look at the meter reading. While he was on the telephone. He was like,
Do you have copies of these bills? Okay, and so they are out of the property, so that's why you wanted to address damages, is that?
Yeah.
Okay, got it. And so after there was a walkthrough, they were notified in accordance with the law of the damages.
Yes, Shannon, we sent them a copy of the estimate that lists out the repairs that were done.
And they're disputing those damages. So
They are.
Not all of them.
Okay,
I'm not disputing all of them.
okay, if you come up with your Board of Water and Light bill, then I'll, if I see it to be reasonable, I can consider abating anything or addressing that if necessary. This ledger, I don't know what you were looking for. What is the error on here?
I think, Your Honor, that the December rent is charged at $699 and then the 801, and then I think it was probably an error. They charged again the December rent through 12/23. I think that was maybe meant to be the other ones was meant to be credited off and then the prorated amount. I think it was just a oversight. It's looking like they charged December twice.
Your Honor, I do have that picture of the bill.
12/23, you said what? But mine doesn't have, it says rent through 12/23. Oh, where it says 1,000 134, is that what you mean?
Yeah, I think they
Okay.
accidentally added rent twice for December.
That's what it looks like to me.
Yeah.
That sounds like it looks like a prorated amount. Is that what the 1134 is?
The 1134, yeah, is the prorated amount, Your Honor. So I think, and it's funny because in my client software, the other two aren't showing on there. So I think that's why my ledger is, I don't know why my ledger looks different, but there's probably an error on it, honestly. So if I back out the 699 and the 801 from the last charge in November, I'm looking at the end of November with the late fees, they owed 1,946. Then I would add on to that the 1,134.13. I come up with $3,080.13. And then there were two charges on here, Your Honor. I don't know if they're being disputed or not. We got only one of the two keys back for the lease. There was a $75 charge for key change. And then there was significant debris that was left in the property that was.
I'm reading emails and you're going through facts. I'm reading emails.
I'm sorry, Your Honor. I'm just gonna keep going until somebody stops me. I apologize.
Okay, so it looks like you're scheduled for a walkthrough on the 4th at 9:30. Thanks so much. Okay. Okay, I see an email where Jennifer Willcutt said that they were gonna cancel the walkthrough that was gonna be scheduled for December 6th. Because the webs were not ready, and she responds within an hour. We will be out by tomorrow. So what happened? They just didn't. She said, we'll be out by tomorrow, and she responded, said, I said, when do you want to do the walkthrough?
Yes, Your Honor, I believe that was the 7th. So she kept asking repeatedly, when do you want to do the walkthrough? At that point in time, my client did not know that the keys were in the property, so she believed she needed to meet with them to walk through and get keys.
Correct, but she responded within an hour of being told that, because she didn't ask to have the walkthrough canceled for December 6th at noon. She said that she's already made arrangements essentially for her husband to be there or to get everything out. That she would not be at the walkthrough because of her child, but that she's sure her husband will be able to. So it wasn't, she didn't cancel it, your client canceled it. and she responded within an hour after they said, well, we'll cancel it. She said, we'll be out by tomorrow.
My client's indicating to me, Your Honor, that Ms. Wolcott was at the walkthrough at the scheduled time of the 6th, and that the web were not there.
Well, when she, how do we know that? Ms. Wilcott's not here, is she?
She's not.
Oh, okay, so I was just told 5 minutes ago, there was no walkthrough. Now, all of a sudden, Ms. Wilcott appeared and they
She
didn't
went
appear.
there just in case.
Oh, okay. I don't believe that unless Ms. Wilcott comes and tells me herself that she was there. I don't see anything that says, hey, we were there for your walkthrough, you didn't show up. I do see on December 7th and 9th, they reached out multiple times about scheduling a walkthrough. When do you want to do a walkthrough? Are you ready for a final walkthrough? And to turn in keys. We need to schedule a final walkthrough on the 11th. Neither one of you wanted to respond?
After being told that they were gonna get drugs and my kid was in the hospital with pneumonia, I just, you know, I didn't.
Well, what was they supposed to do?
And honestly, I don't know. I mean, now looking back at it, probably not the smartest.
You
move,
owe, at
but-
least you owed money.
Yeah,
You,
and yeah, I'm not saying we didn't owe money.
what was they supposed to do if you don't pay the money or vacate?
We vacated, I let them know that, just didn't know, let them know where the keys were, or do the walkthrough.
Okay, and then there was trash. What was the, what's the issue of a trash
So that's,
out charge? It's for her to explain. Trash out and damages estimate from contractor.
Yes, Your Honor, I do have some photographs that explain the damages and some of the debris that was left in the property.
You can explain, you have to make a record.
There's significant debris left in the basement. There's multiple bags of trash. There's probably 1, 2, 3, 4, 7 or 8 bags of trash down in the basement. Huge bags of trash. There's multiple debris. There's like a vacuum cleaner. There's pillows. There's damage to the walls. There's someone drawn on walls and what looks like black or permanent marker. There were a lot of crayons and things on the walls, along with, you know, another pile of looks like a fan and some trash and some other things that were left behind. Carpeting was ruined in several areas due to a pet that was in the home. There was multiple areas that had to be just taken up and replaced. There were multiple blinds that were missing or destroyed that had to be replaced. There were multiple screens that had to be replaced or repaired. These were all things that were new in the property. There was over $5,000 that went into the property before the webs had moved in, including all new windows, all new screens. I'm sorry, 13,000.
How long do they live there?
Was it 2022 or 2023? A year. Oh,
A year.
the move in was November.
So this
of
ledger is the complete
Right.
time frame that they were in the home then. November 2023
Yes, Your Honor. I'd look
until,
back to it.
okay.
Forgot what you were. There was significant cleaning that had to be done to the property. There was deep cleaning that had to be done that was not the normal level of cleaning of a kitchen. There were repairs to a door frame, again, damaged by the dog.
You all can have a seat other than the attorney. She's presenting.
There was significant damage to the carpeting again by the dog, that there was urine stains on the carpeting that had to be, and feces in the carpeting that had to be cleaned and repaired. There was, there's a substantial list of things that had to be fixed. There's multiple places where the trim was broken or the drywall was broken. There's a missing towel bar. In addition to some routine maintenance things. So there was a lot that went above and beyond what you would consider a normal turnover for a unit.
Okay, and you showed this information to the webs,
Yes,
correct?
and they also received a copy.
As well as
in
the
mail.
pictures that you wanted to show the court.
I don't know if I showed them the photos. I apologize, I only have one color set, so.
Well, they just need to see them and then.
Yeah.
If they want to object, they can.
Yeah, the bags of trash that were in the basement is from that pipe that was leaking. And it's not trash, it was clothes that we couldn't take, so we bagged them up, left them. Because they were all completely ruined.
How long was the pipe leaking?
So it had been leaking for, I didn't know it was leaking, I thought that's how it was supposed to, it looked like condensation to me that we used the water and it was leaked just a little bit. When the contractor fixed it, he told me to let him know if it was leaking more the next day. So when I went down there, it had leak and it was a lot,
Okay.
and by
You
the
say
time he.
I'm sorry to cut you off. You say you found the bill, is that correct?
Yes,
he
I
did
did.
find that.
Okay, can you give that to me?
So when he fixed it, I don't know if it wasn't long enough or something, but he did come back and,
Have you seen the bill?
I have not. I can't tell like what property this is for. Or what date it's on it. No.
Well, yeah, the property's right there in the corner.
Oh, I didn't say, I was looking at it.
You want him to email it to you, you can print it. Okay.
that's from their contract here.
You have a color copy? A color
I do,
set
Your
of
Honor.
those?
Oh,
Oh, that, I was gonna say for me, I'm gonna go
Oh.
through, so she can tell me what she's.
am I okay to
disputing.
approach it?
Yes, please. Thank you. Okay, so the first picture on plaintiff's proposed exhibit is, it looks like a basement, that's what this is?
Yeah, the basement.
With bags of some clothing?
Yeah, all the bags you see in any of these pictures are clothing.
Okay, and this is the clothing that you said was soiled from a leak?
Yes.
There's some clear bags, and then I also see some black bags. You're saying all of that was clothing?
All was clothing.
And all of that clothing was soiled?
Yes. And then where the vacuum, yes, we left the vacuum, but those pipes were there when we moved there. There's another thing that was there when we moved there. There was things from the previous tenant still there when we moved in.
Okay, I see a vacuum, a ball, t-shirt. I don't know what this is behind the pole. Looks like it's some toys maybe in the back. Could be a blanket back there. And maybe empty bottles and a clothes hanger.
Yeah, I mean, that's.
Maybe a chair back there?
There's
Yeah,
a chair back
that's
there, you
ours.
said?
Makes sense.
Okay, there's some other things that looks like some empty boxes. In the next page.
In the box, so we went to pick the box up to take, that was something that had gotten wet and we couldn't take the box because it was like stuck to the ground from. Anyway. I'm on the page where there's stairs and there's coloring.
Okay, I just see, look like some markers or something
Yeah, my
there.
2-year-old cat, well, he wasn't even 2 at the time.
Now,
He
this
was,
carpet, was this supposed to be brand new carpet?
It was new, at the time the webs moved in, Your Honor.
The mark on the closet door, that's on the page after the marker. That is from the maintenance when they had came and did it. Now the coloring that's there, that's from, again, the.
Wait, what is from the maintenance?
There's like some scratches on the wall. And that I had told Jennifer.
Some scuffs on the wall?
Yeah.
I'm not
I think
really
it's right
too,
here, but.
really
the-
not concerned about scuffs
Yeah.
on the wall.
And
So,
then the one with that was just like,
what's this yellow thing? What is it?
it was a gaming chair that had broken.
And what is it looks like something's black next to it, and then there's a fan on top of it? Is this inside of like a bin, like a storage bin or something?
No, it's inside of, it was a bedroom.
No, there's something that looks like it's hard and yellow, like a plastic. bin.
Yeah, the hard and yellow thing, that's the gaming chair. That folded
Okay,
up.
got it. And what's in the bag?
That was a bag of trash, but it was like, We got like broken toys, that type of stuff that we were.
Now, there's some discoloration on the wall, but that
He colored, he took a crayon.
from the top all the way to the bottom.
Yeah, he stood on it. He had a bunk bed and stood on it.
Okay, I see some additional debris or trash in the basement. Is that what that is?
That was like lint from a
Mhm, that's what it
dryer.
looks like. And then what's the next is the second to last page. What am I looking at here?
Desk.
Was your desk?
Yeah, and like this, that got forgotten. I
Okay.
wasn't there. It was him and my dad and my mom trying to get everything out to hurry.
Okay, I
So
see it.
some of this stuff is just stuff
Stuff that you
that
forgot to get.
they forgot because they were trying to rush.
And then the last is, it appears to be some lint and
Laundry
Laundry
detergent.
stuff.
everything like that.
I'm not seeing $5,000 worth of damage.
I can have Ms. Wolcott, who just wasn't available today, to come in and I think they.
Coming for what? We're here today. Where's the $5,000 worth of damage?
Well, again, I wasn't sure if we were doing the full damage hearing or not, Your Honor, today. So these photos were intended to show the debris and things that were left behind.
I
There was just a couple photos.
Completely agree that there was a lot left behind. She says she essentially is not disputing that some things were left behind. She wasn't there and she sent other people in her stead. It wasn't the property. Typically, when you move out, you would want to clean it and make it look like, responsible adults live there, but obviously under her circumstances, maybe that's what prevented her from doing that. Doesn't excuse the fact that you got to pay for someone else to dispose of your trash. And so I'm assuming that's what this $800 trash out fee is. And so where's the estimate from the contractor? Replace weather seal on front door, treat carpet with enzymes to try and eliminate the pet urine odor and steam carpet. You gotta do that anyways when you rent to someone that you allow to have a dog, don't you?
I wouldn't expect that there would be urine and feces stains all over the, maybe one or two is excusable, but there, you'll see it in multiple rooms, Your Honor.
Please don't talk when they're talking. This doesn't say, this says urine odor, it doesn't say feces. It says.
Do that.
Paint the entire living room. You should gotta paint the whole unit when people move out anyways.
I don't know if the whole unit should be painted after only a year, Your Honor. You would think there would be something that.
Wow. You do gotta get in there and touch up just from moving. You can scuff up walls moving in. This is not a new unit. It doesn't appear to have been a newer facility. I do see some markers or color crayon or something on one wall. That likely could have been bleached out. I don't know if that was even attempted. And then there was a marker that looks permanent. And then the other looks like scuff that she said that she didn't even create. Even coming in and painting a unit after someone vacates, that's normal. I'm not going to hold them responsible for that. The major issue that I have here is this estimate. It's not even telling me how much they're estimating for certain things. It's just saying total material is 1680. Based on what? Where are we getting? What is the itemization there? And then labor, total labor, 3,850 for labor. This is kind of quite arbitrary, if you ask me. It's not really giving me any clear indication as to how long it's going to take for any individual task. What's the rate for me to believe that it's reasonable that that's the labor cost for them to come and do that? I don't see a picture of drywall that's been broken. The retreating of enzymes through or treating the carpet throughout the house. Carpets need to be clean and treated. I think whenever you have people living on there, they have children. Children can urinate on the carpet. Anything can happen. Food could be stain it. That should have been addressed regardless. It's mentioned a number of times here for each room. I don't think that that's gonna help to drive up the cost just because you had to steam clean all the carpets. If I could see proof of a hallway, or drywall that needed to be fixed, that is, and proof of the destroyed, it said remove destroyed carpet. I don't see any evidence of that in these pictures. It says prep floor and install waterproof laminate flooring, $286. Is that total? Like, what is, how much, what is the flooring? I don't know how that's priced. It doesn't explain that. Repair drywall, and it doesn't show me a picture of why it needs to be repaired or what the alleged damage is. It says replace broken or missing doorknob. I should see how much it costs for the doorknob. Repair drywall again. I don't see any evidence in the pictures. I just see debris that was in clothes that was left over, which she claims was damaged due to a leak, which, if that's the truth, someone might owe her money for her having her clothes damaged. That's a lot of clothes. But I don't know if I don't know that to be the case. I haven't received the bill about the water leak in the basement yet.
The way it's set up, it's like split.
It's what?
It's not like a minimal style. It's not usable.
Let me see see what it is on the phone. Remove chalk or remove caulk and recaulk entire tub and shower. Why did the caulk need to be removed?
Some of those things, Your Honor, I will say that, and I've explained to my client, we're not asking for the routine maintenance type thing. The caulk needed to be replaced. That probably would have fallen under routine.
I can answer.
Well, it's not your responsibility. If you actually have, you can say nothing. This is their case. The more you say, the more trouble you might end up in. No, to the contrary, it's on here. 5,430 for damages. You are asking for it. Damages are denied until you can prove it. And you can have another hearing date if you'd like to present evidence on those, on the damages. And I can give you that date today, but we'll address the past due rent in just a moment, because they're not disputing that they owe rent. And based on that, they should owe rent. They didn't vacate the property until December 6th. They say there's a question as to whether or not they turned over the key. Does your client have a copy to get in the unit? Is that what the issue is? How did
They're bones. Landlord. So do not get in until you have-
you left the key where, ma'am?
Right on the railing in the house, but the door was unlocked for them to get in. Those stairs that you see where the mark was at, there, it's a whole.
This is an apartment building or a house?
A house.
I will say, Your Honor, there's no indication in any of the correspondence that that was how the webs intended on leaving. If they had said that, my clients probably would have gone over there to secure property because they wouldn't have wanted an unlocked property sitting there.
He's got all I see is what this says past due. I need to see, that doesn't, just because it's past due doesn't help me know that that's because it came from a leak. So when you come back for the damages, you need to bring a printout evidence of the bill that you received and as a result of the leak. I don't want to just see a past due bill because you didn't pay it. It needs to be as a result of a leak. And then as it relates to the amount in past due rent, I believe that I think it was reasonable. I think that you should owe a rent for the time that you occupied that property. And I believe you should owe a prorated amount for the time that you occupied in December. I don't know why there was this miscommunication between the 5th and the 23rd. All that time went by without us understanding that this property is vacant and the keys are in there. But they did notify that the property was vacant. And so I think it's reasonable that the property should have been secured by then. Let's See here, we need to schedule a final walkthrough. And what day will you be ready to hand in keys?
I will say, Your Honor, my advice to my clients is always, unless you have keys, you don't have possession. Just because a client or the tenant has indicated that they are moving out, I would have still told them, unless you've gotten keys and you've gotten confirmation, don't go in that property.
I reckon that's probably what you advise your clients, but she said that they vacated. What if they lost the keys?
Well, the issue, Your Honor, is she said that we are going to vacate. They didn't say that she didn't say she was out. She
But
said we
what-
will be out.
So what if they lost the keys? So that means your client doesn't have possession because they didn't get keys?
And there needs to be some communication on that, Your Honor. If you lost both of your house keys, I think that's an issue.
I agree, there should have been some, they went mute, but they also, I understand, was in the middle of a bit of some crises mode. It says, unfortunately, we need to file an eviction, and she said that she was going to cancel the walkthrough. And she responded within an hour, we will be out by tomorrow. I do agree that there should have been some confirmation that you were out. You say you talked to someone on the phone. I don't know when that was. You told me that you dispute it was the 23rd, but you're not providing me anything else. I don't know if you have phone
I don't
records.
have a phone record of.
Because you got a different phone now, right?
Yeah.
No, it's always that way. It's always a different phone. Okay, well, prorated amount, I believe is appropriate, because that was when they could finally confirm or get response back from you that you were not in the property. I think that there was an issue with it being charged full rent, and then on this ledger at least, and then the prorated, so the amount that, if we subtract that, the amount that you believe they owe is what?
So if I go from November, which shows a balance of $1,946, I would add on the $1,134.13, which is a total of $3,080.13. And then there was also a key. One of the keys apparently was never recovered, so only one key was left in the property. And then
You had two keys.
Yes.
Where's the other key? Why didn't you leave both?
Where
You said they were both there?
they were both there.
Okay, well, that's, you know what happens when you're not present to turn over the keys and do a walkthrough? Anything could happen, and you're not there to dispute it because you weren't there. They said they only got one.
Can I say something? else?
You absolutely can.
They did do, they went through the house and did a city inspection and knew we were out of the house.
Who did a city inspection?
I believe it was Jennifer, because when me and her talked, she said, so you don't have this at the house and you don't have that in the house. It's like, yes, but we have left.
What date was that?
It was when we talked, and again, it was right, I believe it's in those emails.
A city inspection for what?
They were doing a city inspection.
For a rental certificate? What was it for?
I don't know what.
that's
they
what my
just-
client's guessing. I'm sorry.
You're fine. A city. Okay, so December 16th is at 3 p.m. So I'm going to say, so it was like the 17th that me and her talked, December 17th,
So not too far off.
not too far off.
Was there a valid rental certificate when they were staying there?
As far as Maria, yes, Your Honor.
As far as you are aware?
Yes, sir. I haven't specifically asked my client that question, but you never had a lapsed rental certificate, was there? No, no, Your Honor, that there was a valid rental certificate.
Okay, I do see that it was reissued on the 20. Okay. It was issued at the beginning of January, so that means there's some point they went in there, probably in December, to do an inspection. I don't know when they did the inspection. And if they did do an inspection on or around the 6th or the 7th, then they would have known the property was vacant, or could have assumed that it was, and should have saw the keys. Also should have known that the property was left unsecure, which could be a problem. But I don't have any information. You're not providing me with any information to give me an actual date of when that could have happened, so I can't guesstimate when that is, okay?
She said they were coming, it was the email right here, so it's the 16th, that they were coming for the city of Lansing code of compliance, and she said that they'll bring a key.
She emailed you
Yeah.
and said that when did she email you?
It was the 11th that she emailed me,
The 11th of what?
of December.
That they're coming to do an
To do an
inspection?
inspection at 3 p.m. on December 16th, and that management will bring a key.
Did you respond?
I did not.
Okay. So then I believe that they believed, at least as of the 16th, they believe you were still living there. That's why they're notifying you that they're coming for an inspection. And you have all these messages. I understand your child was ill, but that doesn't mean that you can't stop and respond. I held a whole eviction docket from ICU with my mother. It's your responsibility to take care of your adult business. He didn't do it. And you can't use the excuse that your child was ill, so you couldn't take 2 seconds to respond and say, we're out, we left the keys on the counter. 2 seconds. And so judgment as to the past due rent will enter in their favor for the amount due $3,080.13 plus $75. And then we will continue to a new date so that you can bring evidence and or the other witness that needs to maybe testify as to damages, because I don't have anything for damages. I only had, well, also, I do have the trash. I would agree that the trash needs to be paid for, but the other damages, correct. But I don't have the other damages.
I'd also ask for routine court costs and attorney fees.
We can do, you want to do that now, or do you want to do it when we return for your next date? I'm gonna give you a next date now. For your damages.
Sorry, I'm sorry. Your Honor.
This sort, take your time.
My client's indicating she'd like to try and talk through the damages if you're willing to after the hearing, maybe we can avoid that altogether. Your Honor.
To come to maybe a resolution.
Yes, sir.
That would be probably in their best interest. You have a Section 8 certificate?
Yes.
It's in your best interest to have worked out something to avoid an eviction on your record anyway. You know that you can lose your certificate if you get this on your record.
And a lot of the, like the costing that you were asking about, that was because Section 8 asked for that to be redone.
Yeah, well, then you should have brought evidence of
They
that
won't give
today.
me, they won't give me that. I
Who
asked
won't give
for
you?
Section 8, they will not give me.
They came and did an inspection and you don't have a copy of why they would have.
Oh, I have a
either-
copy of what needed to be done, but they won't give me a copy stating everything that needs to be done. I asked for it and they said they couldn't, that's something they're not allowed to do. I do have those emails too from my caseworker.
Okay, well, you can give us your case note workers name. If we have to proceed to hearing, we'll subpoena her. But it sounds like you all probably could come to a reasonable understanding, because as I said here, you owe them $3,875.13 so far, past due rent, trash, and a key. And then there's some, I think you all need to go through this list as it relates to the damages, because it's not itemized. I don't have any evidence. You seem reasonable. It doesn't sound like you're disputing that there was some work that needed to be done. Maybe you all can come to a resolution, even come to a payment plan if possible, and see if they will work with you to get an agreement on the record.
Maybe we take 10 minutes, Your Honor, and see if we
You can
just
take,
have-
yeah, you got more than that if that's what you need. Off the record.
Thank you.
Is he on the record down there?
It's David.
Let me see, is that the only other one we're waiting for?
No, we have,
Tammy
Tammy
Rogers and Alethea Moss Kelly present.
Miss Moss Kelly is not.
Alethea Moss Kelly's not here?
No.
Oh, that's too bad. Tammy Rogers? Yes. Okay, you can submit default. Do you know how to do that paperwork? Is the property vacant?
She hasn't been there. I haven't seen her. It's almost like she just disappeared.
So you don't know if anyone's inside the property or if there's items there?
I know she's not there. I know that there's items there.
Okay,
Yes. So,
items as if she abandoned them or it may come back, or?
you know, it seems that I haven't seen her and she just disappeared. Last time I saw her was on that screen, when you ordered us to come back on the 26th of March. And I think you offered her
To meet with legal
to meet
services?
with I think his name is Ulysses.
Oh, the eviction diversion facilitator.
Exactly.
Okay, okay, yeah, I do see that it was, you were present and then on the 26th, and I said to appear today for in person for hearing.
Yes.
She's not here, and you have no indication that the property has been vacated, so default judgment will go in your favor. We can print that paperwork for you now.
Okay.
Thank you.
Sounds like a plan. So at this point, this is my first time going through this, so I'll find
So
out.
we'll get you the paperwork. We'll give you a copy. The paperwork will give a writ date on it. That, it's gonna be 10 days from today. And so what is the writ date? What is today's date? Actually? So the writ date must be the 14th. I'm assuming, yeah, because the 10 days from today is on Saturday. And so it will, after that date, you can come and get a judgment to execute if she still hasn't vacated the property.
After 10 days, okay. So come back in and.
Correct. Now, I don't know if there's electricity, heat, or whatever going through the property. We've got some weird weather issues. If you did need to get in the property immediately, I can let you make a motion for that. I don't know the condition of the home.
Well, the last time anything had come up, it was a breaker issue with the stove, and we figured that out.
No, I mean, as it stands now, like, we're between, it gets pretty cold at night. And so I don't know, it's what, 37 degrees right now. I don't know if you need to get in there and make sure its temperatures are appropriate, so your pipes don't freeze. I don't know.
I take care of the gas, so everything is.
All that's on. Okay,
All three.
sounds good. So we don't need to worry about that. So yeah, you'll just come back in 10 days. Mr. Bach, are you ready in your matter?
Yes, Your Honor.
Is that it, right?
Just have a copy. We'll get you a copy of the paperwork in a couple minutes. Okay, on the record in the matter of Lansing 7-4 versus Gretchen Bogan 25-01 069, appearance, please.
Yes, good afternoon, Your Honor. Ronald Spock here for the plaintiff.
Okay, today was the date as scheduled, and you're Miss Gretchen Bogan, correct? That's scheduled for pretrial for hearing for non-payment of rent, and the parties have come to resolution. Can you state the agreement on the record?
Yes, Your Honor, we've agreed to a consent order for conditional dismissal. At this time, the rent due is $2,600. That's due through April. The cost of $183.85 for a total of $2783.85. Ms. Hogan, the normal 10 days is the 14th. We kicked it out to the 21st. She's gonna have it paid by then. And if she does, it'll stay dismissed forever.
Is that how you want to proceed, ma'am? Okay, you understand that you had the right to be represented by an attorney at this hearing? You had the right to proceed to a trial. You could have demanded a jury trial. Did you understand that?
Yeah.
Do you want to give up both of those rights so that you can move forward with this conditional dismissal?
Yeah.
Anyone threatening you to give up those rights? Okay, so you're gonna agree to pay the past due rent plus court costs, $2,783.85. That's for rent due through a period of April 30th, 2025, and you'll pay that or vacate as on or before the 21st of April, correct? You have 3 business days from today's date. If once you leave here, you realize you misunderstood your right, you can return to the court and request to have that agreement set aside and explain how you misunderstood your rights. Partial performance will not satisfy that agreement, so you gotta do exactly what you said you were going to do in order to keep this matter dismissed. Otherwise, if you don't do it, Mr. Bob or his office could file to have a judgment entered against you, and you will not get a notice for a new court date. You understand that? You have any questions? We'll get you a copy of the paperwork in just a moment. Any additional matters?
No, Your Honor, my last one of the day.
Look at you getting out early.
Early, I'm 15 of them.
It's 3:15. It could be 4:15.
You can start arguing about stuff.
I don't think that's necessary. I think we would prefer not to. Thank you. You can have a seat, ma'am.
Lay down the hall, wanna fight.
Down the hall.
She wanna fight me, the way she's looking.
Oh, boy. You stay safe out there. Did you need an escort to your car?
we were able to reach agreement.
Wonderful.
I'm good.
Careful.
I'm tripping. I'm going. No, you're good. I put it in a weird spot.
Let me take this.
Thank you. I'm gonna break my neck.
Okay, back on the record, in the matter of Sandy's property, versus the Webbs, and you came to a resolution.
We did, Your Honor. I have a total of rent, late fees, the key fee and trash out being $3,955. We've agreed to settle the damages issue within a payment of $2,000. The Webbs have a security deposit, which my client has on hand of $1,500 that will be applied towards that. So that leaves a total amount of $4,455. The Webbs will make an initial down payment of $1,000 within 14 days. Beginning May 1st, 2025, they'll pay $100 per month. With the intention being that when they receive their tax refund for 2025, yeah, in 2026 for 2025, the tax refund for next year, that they would pay off the balance over that.
Okay, so you're doing a consent judgment or a conditional dismissal?
I'd be happy with a conditional dismissal if that would avoid impacting their Section 8 funding.
Okay, is that what you want to do, a conditional dismissal? And so that we will get that paperwork drafted up as soon as she gets here, or we can print it and you can draft it. So you would have to give up your right to have a trial and your right to be represented by an attorney. And the case will be dismissed so long as these conditions are complied with. If you breach the condition, impartial performance will not satisfy it. So you gotta comply completely and accurately as to how you stated or how it was stated here on the record. Otherwise, they can request a judgment entered against you for your failure to comply. You will not have another hearing for it. Do you understand that? That's how you want to do it? We will get your paperwork printed and then counsel, you can get it executed. And then we've already put it on the record. So
I can just hand it to your Honor
you
staff.
just hand it to me once it's signed. Yeah.
Do the Webbs need to wait around for their copy once
They're
you
gonna sign it as well. I'm
Okay.
gonna say, yeah, they need to both sign the conditional dismissal.
Okay, thank you, Your Honor.
Thank you. Ma'am, are you waiting for a court date?
No, I'm done with them.
Oh, okay.
I'm the next turn.
Oh, it makes me feel better about whatever happened there when she tripped. Yeah.
When I tripped over another.
It wasn't just a
Tripping over my
stranger.
own kid. She trips her, I saw it.
It's all personal. They're together.
Erica is graduating from law school. soon,
Oh,
so-
congratulations.
Thank you.
What law school?
Cooley Law